Welcome to Atheist Freethinkers online event at an unusual time, so we can welcome a few visitors from the other side of the planet. We have a couple of attendees from Australia and one from Ireland, and a few members of our organization. Our topic today is Quebec Bill 21. What is it? Why do we support it? And what is the situation with the court challenge to it? Because it's been before the courts. I'm going to share my screen. I have a presentation. There. Can everyone see? Okay, good. I'll go back to the beginning here. Okay. Now, Quebec Bill 21 is a secularism law, and it's actually quite moderate, quite modest. It doesn't do a lot, but what it does do is more than a lot of other places do, and it has garnered an awful lot of opposition, even though it does so little. But what it does is good. First of all, I should define what secularism is based on four principles: equality of treatment for all, including equality of the sexes, freedom of conscience, religious neutrality of the state, and I specify strong religious neutrality. I'll explain that on the next slide, and separation between religions and state. And I consider this last principle to be absolutely essential. If you ain't got separation, it ain't secularism. That's my point of view. Because if religions and state are not kept separate from each other, then all the other three principles are compromised. The religious neutrality is compromised. Anyway. On to religious neutrality. I identify two kinds of neutrality. Strong neutrality is when various systems of belief and non-belief are considered equally, whereas weak neutrality is when there's only neutrality among various systems of belief, but non-believers are not treated equally. In other words, atheists and non-believers are excluded. And an awful lot of religious people have this idea of neutrality, and they end up so that religion ends up keeping a privilege based on the exclusion of non-believers. Sorry. Now, for secularism to be complete, freedom of conscience must include both freedom of and freedom from religion. I should point out that there's one small but significant difference between the definition I've given you of secularism and the definition that's actually in Bill 21. It says freedom of conscience and religion, and in my opinion, the of religion has to be removed. Unless you also add freedom from religion, and because freedom of conscience includes both of those, and so to mention freedom of religion explicitly, you're actually giving a preference to religion, which it does not deserve. Of course, as I said before, religion must be separated from the state because it's dangerous whenever it attains any kind of political power or influence. The principle of separation is essential because without it, the other principles are compromised. For example, the equality between men and women is compromised because there's so much sexism and misogyny in various religions. So if there's not complete separation, equality of citizens is compromised. And as I mentioned, religious neutrality should be of the strong type. Now, this is how I see sorry. I have an indication that I need to move this window away from the shared screen, but I don't know how to do that. Let's see. Okay. I guess that works. This is how I see freedom of conscience. I see it as something that includes both freedom of and from religion.
Mm-hmm.
And the two intersect. That would include freedom of apostasy as well, the freedom to leave one religion and adopt another, or adopt none, and become an atheist, or the freedom to be an atheist and then to adopt a religion and whatever. Now, Bill 21 was adopted in the Canadian province of Quebec. It's the only province in Canada which has a majority that is French-speaking. The draft bill was published in March of 2019. It was adopted 3 months later in June by the National Assembly in Quebec City. And also, right around the same time, just a few weeks later, the government finally removed from the Legislative Assembly, the National Assembly main chamber, a crucifix that had been hanging over the Speaker's chair since the 1930s. Very notorious, and unfortunately the removal of such symbols is not specified in Bill 21. That's one of its weaknesses. But the government did remove this worst religious symbol of all, because it's actually in the Legislative Assembly. So that is fortunately gone, and good riddance. Now, what are the strengths of Bill 21? It gives a clear definition of secularism, similar to the one I gave earlier. It adds this definition to the Quebec Charter of Rights and Freedoms. It bans the wearing of religious symbols by civil servants in positions of authority, including school teachers. Civil servants in positions of authority, that means police, judges, prosecutors, and prison guards. So add school teachers as the 5 categories of civil servant. And there's a ban on face coverings, which is wider than the ban on religious symbols. It covers all civil servants and users. In other words, if you want to receive services, civil services from the government, you have to, show your face. And the ban also applies to members of the National Assembly. That is, members of the provincial parliament in Quebec City. Now, the weaknesses, certainly Bill 21 is far from perfect, and it's very moderate, actually. As I've indicated, it applies to only part of the civil service. It applies only to teachers and principals in public schools, not to other personnel. It doesn't apply to private schools at all, even though in Quebec, private schools do receive a lot of public funding, like 60% or something. It doesn't apply to childcare centers, and that's a significant omission because children, okay? It does not apply to members of the National Assembly. It's only the ban on face coverings that applies to them, but not the religious symbol ban. And it does not apply to installations. This is a major omission, in my opinion, as I was discussing earlier. The removal of that crucifix from the National Assembly and from all other state buildings should be in the law, in my opinion. Other weaknesses: it has a grandfather clause, so that somebody who had a job in the civil service before the law was published in March of 2019, they can continue to wear a religious symbol. I think that's a bad idea. It should have been limited. I would have had that with a limitation of, say, 2 years or something. You got a couple of years to get used to this new law, but there's no limitation on it, unfortunately. It doesn't touch fiscal advantages at all, and that's a major problem. And it also does not touch the so-called ERC program, which is a compulsory part of the school system in Quebec. There's an ethics and religious culture program, which is very bad. It teaches several religions. It's supposed to be like multi-religious, but it presents a sugar-coated and really pro-religious point of view, tends to present all religions as by their more fundamentalist and pious variant. And it sort of transmits the message that, oh, isn't it wonderful to have a religion? And if you don't have one, you should probably get one. That's sort of the attitude. Fortunately, the government has since announced plans to reform ERC, but we still don't know what that's going to be. We don't know what exactly they're going to do yet. Now, this is how I see secularism. in terms of spaces. There's not two spaces like public and private. There's three. And secularism applies mainly only in the civic space. There's the private space, you know, at your chez soi, you know, everybody in their home. There's public, the street, the stores, public buildings that are not government buildings, they're not state. And then civic space, those are state buildings, state institutions, state employees. And that's where secularism applies. So the wall of separation, so to speak, is somewhere here between public and civic. Okay? This is where secularism applies. Now, whoops, back up. Now, why is it important to ban religious symbols worn by civil servants? Well, if civil servants and teachers are allowed to wear religious symbols, then that's incompatible with state religious neutrality, just as much as any symbols on walls. This is especially important in schools. I mean, students in schools are going to have their eyes on the teacher much more than they're going to have their eyes on a crucifix on the wall. Crucifix on the wall is unacceptable, and it's also unacceptable for the teacher to wear a really blatant religious symbol. Such a symbol is incompatible with separation between religion and state. Also, in a Supreme Court of Canada decision back in 2015 concerning a municipality in Quebec where the mayor imposed a prayer at the beginning of each meeting, that was struck down. He can't do that anymore. But that decision emphasized the importance of state religious neutrality, and it talked about the fact that state employees must be both neutral in their behavior and in their appearance. It didn't talk about religious symbols. It didn't go that far. It wasn't that explicit, but it implies that, you know, it says that the appearance of a state employee must be religiously neutral. So that implies no religious symbols. To allow a civil servant to wear a religious symbol is a privilege. It's a religious accommodation. It's accommodating a religion, giving a privilege to religions. It's a form of religious advertising or passive proselytizing. And it's discrimination against atheists and other non-believers who have no particular symbol to wear. I mean, we could adopt one and start to wear it, you know, out of revenge, but no, not a good idea. I don't think. You know, most atheists are very discreet, so there's nothing to ban for us. Now, this type of ban on, you know, people accuse the bill of being discriminatory. It's not discriminatory. It's disciplinary. It restricts certain behavior, not certain people. Just like laws banning smoking. If smoking is forbidden in a certain place, that doesn't mean that smokers can't enter. It means that people can't smoke when they're there. It's behavior which is restricted. Anybody can enter, but while you're there, you can't smoke. And if you want to smoke, you have to leave and smoke elsewhere and come back. So it's a restriction on behavior, not on identity. Banning on religious symbols, they're like speed limits on highways. They apply to everyone. To say that banning religious symbols discriminates against believers is like saying that speed limits discriminate against owners of fast cars.
Yeah.
The rights of some end or become limited where others' rights begin. We're talking here about balancing the rights of some with the rights of others. One moment. See if I can correct something here. Okay. Small technical problem. Okay. Now, so freedoms and rights are not absolute, except freedom of thought may be absolute if we're talking about just freedom of belief, totally internal in your head, unless you've got thought control or something. But freedom to practice a religion or to practice anything is never absolute, because as soon as it starts to impact other people, there may be limitations. And wearing a religious symbol is a religious practice, not a religious belief. Bill 21 puts no restriction on religious belief, on no restriction on freedom of thought, anything like that. It's simply a question of practice, because that practice impacts other people, and the person we're talking about people who are agents of the state, working for the state, and they should be neutral. And of course, a religious symbol can be removed. There are some people who claim, oh no, I can't take it off. It's like it's welded to their head or their body. You know, it's ridiculous. Anyway, Bill 21 is moderate, even timid. There are religious symbol bans in several European countries, which go further than Bill 21. There's a law in Geneva, Switzerland, which was passed recently, which is similar but stronger. There's something really interesting in the Geneva law. It's the Republic and Canton of Geneva, it's called, in western Switzerland, just on the border with France. And the law applies. The religious symbol ban in Geneva applies to the entire civil service, but it says that they can't display or express their religious preferences when in contact with the public, which I think is very good, because it explains why this ban is there. It's because they're in contact with the public. And so strictly speaking, I suppose somebody could, a woman could wear a hijab when she's working back in the back office, and then if she has to serve somebody else to get off it wouldn't work very well. But anyway, the basic idea is it's because they're serving, they're representing the state in serving the public, and it's stated in the law, which is, I think, very good. There are face covering bans in many countries, far more than religious symbol bans, and several Muslim majority countries have bans on the niqab or the burqa. I believe in Morocco it's even illegal to make the burqa. Its manufacturing has been forbidden. And so Bill 21 is groundbreaking in North America, but it's in no way extreme. It's rather bland for other countries. Now, to remove one's religious symbol at work, especially when working for the state, it's a form of professionally ethical behavior. It's professionally unethical, in my opinion, for an employee to wear a blatant symbol, religious, political, or commercial, while they're on the job, especially if they're representing the state. The Quebec Public Service Act already bans, it's been on the books for years, long before Bill 21, it already bans partisan political symbols and behavior for civil servants. And it's much stronger. It applies to the entire civil service, and it even has implications outside the job, which Bill 21 does not have, of course. And so Bill 21 just applies a similar ban to some civil servants for religious symbols, which is very eminently reasonable. Bill 21's ban is a benefit for everyone because it helps to protect the religious neutrality of civic space. I'm using the word civic here. That's the third of the three spaces. And keep in mind that no religious practice is truly an obligation. That is, if somebody tells you, well, I've got to wear my kippah, or I've got to wear my hijab at all times. No, you don't got to. It's because you choose to. Either you choose to, and it's a choice, or somebody else is forcing you. And if somebody else is forcing you, then there's a problem, and maybe we should help you to get to get away from that obligation, so you can choose what you want to do. But it's never truly an obligation unless it's a form of coercion, which is unacceptable. Now, the arguments against, well, there is only one. The arguments against Bill 21 are generally pretty weak, and so the opponents tend to indulge in gratuitous insults. But there is one argument, that is, the law limits freedom of religious expression for civil servants and teachers. This is true, but it doesn't. But this is it affects freedom of religious expression, not freedom of religious belief. And if it does that because the expression impacts other people. Unless we completely neglect the rights of civil service users and public school students, then we have to limit the freedom of expression, religious, political, or commercial, of state employees. You wouldn't want a teacher or a police officer to be wearing an ad for McDonald's hamburgers on their chest, right? That would be commercial expression.
Yeah.
And you wouldn't want a political symbol, a big photo of Vladimir Lenin or a slogan that says, vote for Aaron O'Toole, Conservative Party of Canada, or vote for Quebec independence, or vote against Quebec independence, or whatever. Political. These are things which people can indulge in off the job, where you're, or where you're atheist. I wouldn't wear an atheist T-shirt to work if I worked in the civil service, but I might put it on when I ended my shift and left and was leaving work. Okay, so we're dealing with conflicting rights, and we have to find an equilibrium, and this is a good way of doing it by applying a religious symbol ban to employees of the state, but not to users of services. Now, this law has been challenged, greatly challenged before the courts. Step one, there was an initial step immediately to try to get the ban suspended, the religious symbol ban and the face covering ban suspended immediately because they were claimed to be harmful. And it went through 3 stages, and they all failed, fortunately. In July of 2019, only a month after the bill became law, Quebec Superior Court Judge Michel Hiergeau ruled against suspending any of Bill 21, and he when the complainants claim that the bill, the ban on religious symbols causes prejudice against religious minorities, he said, no, it doesn't. It's actually designed to do the opposite. This kind of limitation on religious privilege is meant to solve problems and to reduce tensions around religion and reduce prejudice against religious minorities. That was appealed to the Quebec Court of Appeal a few months later. There were 3 judges, and one judge agreed with suspension, but they were outvoted by the 2 others. So 2-1 decision, rejecting the appeal. And then finally it went to the Supreme Court of Canada, which refused to hear it. They gave no explanation. They just, no. So that first challenge failed, but that was only to get an injunction to suspend part of the law immediately. Then there's the real challenge, number 2, which is an attempt to have the entire bill struck down. And this took more time, and there were at least 17, I lost count, maybe there's 18, maybe there's more, challengers who were attempting to have Bill 21 repealed. There were several individuals, veiled Muslim women, a turban Sikh woman, and a whole bunch of organizations, and I find it really awful that I'm not surprised that the National Council of Canadian Muslims is opposed to it, but when you have organizations like the Canadian Civil Liberties Association or Amnesty International or the Canadian Human Rights Commission, I find this really pathetic that such organizations would take a position against a law which is, pretty innocuous, but it's a good law, it's a progressive law. The English Montreal School Board opposed it. Lord Reading Law Society, which, by the way, I believe the judge who voted in favor of suspending parts of the bill back in Quebec, the Quebec Court of Appeal, she has some links to this law society. So there's a bit of a conflict of interest there. And also there were some unions who opposed it. One of those, the teachers' unions called the FAI, the Fédération Autonome de l'Enseignement, and they have not consulted their members on this issue since 2012. And back in 2012, an overwhelming majority said they're in favor of banning religious symbols for teachers. Way back in 2012, and they haven't bothered to consult them since. But they've spent a load, a load of money contesting this law. And there was also the Civil Servants Union. I'm not sure. I don't think they consulted their members either, but I don't have the details on that. So, who intervened in support? Well, though, of course, there was the Quebec Attorney General, the government of Quebec, which supported the law, supporting its own law, and 3 intervenors, the Mouvement Laïque Québécois, and their approach was to the rights of parents to protect their children from being exposed to religious indoctrination that they disagree with. And then there's a feminist organization, Pour les droits des femmes du Québec, and their main theme of their intervention was protecting women from religious misogyny. For example, the hijab and the niqab and other forms of the Islamist veil are symbols of the subjection of women. And us, Libre Pensabilité, Atheist Freethinkers, and our main acts was to talk about the concept of freedom of conscience and the fact that it includes both freedom of and freedom from religion. Otherwise, it's incomplete. I should mention that the MLQ, the Mouvement Laïque Québécois, they were behind the Supreme Court case that I mentioned a little earlier in 2015 about the prayer in a municipal council meeting. They're the ones who took that all the way to the Supreme Court of Canada and won against the mayor of that city. So thus stopping him from imposing prayer on city council meetings. So that was an excellent decision that they were responsible for obtaining, and they used that. They gave that a lot of importance, of course, in their intervention because as I told you before, the Supreme Court decision said that state employees have a duty to be neutral in both appearance, in both behavior and appearance. Now, in our intervention, just to give you a few more details, we indicate, as atheists, we welcome the objective expressed through Bill 21 to end certain religious privileges. Indeed, to allow civil servants and school teachers to indulge in ideological displays while on the job, simply because their ideology is religious, constitutes an unjustifiable privilege for religions. The consequences of this privilege are, number one, infringement of the freedom of conscience of users of social services and of students in public schools by exposing them to passive proselytism and indoctrination, which these partisan religious manifestations represent, and two, discrimination against atheists and other non-believers in their relations with the state. It is therefore imperative that state representatives refrain from wearing religious symbols in order to put an end to this discriminatory privilege. A few more details about our approach. We oppose religious indoctrination, especially of children. Legislation should not protect religions in any way different from or superior to any other system of values or ideology. A religion is no different from shouldn't be privileged any more than a political ideology. In fact, a religious symbol, when worn by a civil servant, becomes political, in my opinion. Freedom of conscience subsumes the internal dimension of religious freedoms, the right to apostasy and the right to be free from religion. This is the internal part, freedom of belief, the part that may be absolute. Whereas the external manifestations of freedom of religion are limited to freedom of expression only. So when a person is expressing their religion by wearing a religious symbol, it's a form of expression. And that expression, it may be reasonable to limit that expression if the person is working as a civil servant. Now, in the court case, which was held last November and December, at the end of last year, took about 6 weeks. The arguments of the adversaries of Bill 21 were really, well, they were really awful. Well, of course, playing the victim, religious discrimination, poor, discriminated religious minorities, blah, blah, blah. But there was a real theme of race-religious conflation, so that they could accuse Bill 21 of being racist. In other words, they treated religion as if it were a personal, immutable characteristic, like a racial identity, like having black skin. But what this does is it totally negates freedom of conscience. A religious affiliation and a racial identity are completely different. A racial identity it's a biological property, whereas a religious affiliation, it's an opinion, and your opinions can change. And if you treat it as an immutable characteristic, like skin color or the shape of your nose or whatever, then that means there's no freedom of conscience. That means that the person is the prisoner for life of whatever religion they had the dubious luck to be born into. Arguments against, they also argue that Bill 21 discriminates against women, especially Muslim women. Bill 21 bans religious symbols for all religions, okay? And for employees, men or women, no distinction, but they claim this. They compared Bill 21 to Donald Trump's Muslim ban in the United States. They said Bill 21 requires people to renounce their religion, which is complete nonsense. It's a blind lie. They compared Bill 21 to the Nuremberg laws of Nazi Germany because it foments genocide. It was pathetic, and the judge let this pass. He didn't say he agreed, but he listened to this as if it were a cogent argument. It was horrible. Anyway, by banning religious symbols worn by judges, Bill 21 violates judicial independence. Oh, really? Or in a couple of occasions, arguments for the bill were dismissed because they were made by an older white male heterosexual. Like, what the? This is complete nonsense. Clearly, an idea is valid or invalid independently of the person who expresses it. I think that any court of law should know that. And so it just went on and on. It was horrible, quite frankly. So as I said, it happened in November and December 2020 in Quebec Superior Court, this court challenge. The decision was rendered just a couple of months ago, less than 2 months ago. And the decision validates most of the bill, but uses 2 loopholes to do as much damage as possible. The judge, Blanchard, he struck down the ban on face coverings for members of the National Assembly in Quebec City, and he struck down the application of the bill to English language schools. Now, how the heck did he manage that? Well, first of all, it's obvious from his reading his judgment of 240 pages and also from his behavior during the proceedings in November and December that he was overwhelmingly biased against the bill and against secularism. So he tried to do as much damage as possible to the bill, but he was greatly limited because the authors of the bill invoked the derogation clauses or notwithstanding clauses of 2 charters. There's the charters at human rights charters at 2 levels here in Quebec and at the federal level, the Canadian Charter. And in the Quebec Charter, there's a section 52 which allows laws to state explicitly that they're not respecting a particular part of the charter, and that's what they want, and they're allowed to do that. And section 33 of the Canadian Charter is a similar thing. It's called the notwithstanding clause, but it's limited for 5 years, so it has to be renewed every 5 years if a law derogates from something there. So Bill 21 invoked both of these, and these clauses, these derogation clauses, they represent a balance of power between the legislative and judicial branches because, as I was saying earlier, no rights and freedoms are absolute unless they're totally internal. And so here we're dealing with, if the legislature and the judicial branch disagree, then there's an equilibrium here with these clauses. So those two loopholes are Section 3 of the Canadian Charter grants the right to vote and eligibility to serve in the legislature. And it's not covered by the so-called notwithstanding clause. So it's not, you can't be derogated. So the judge used that to exempt sitting MNAs, members of the National Assembly, from the ban on face coverings. So for example, you can have a member of the provincial parliament who wears a niqab or a burqa in the legislature now, whereas the bill would have banned that. And Section 23 of the Canadian Charter deals with English and French minority language rights. And he used this to exempt the entire English language school system in Quebec from Bill 21. The consequences of this is that it partitions Quebec along linguistic lines. It discriminates against English-speaking children because they are now not protected by Bill 21. And does this mean that French language schools in English Canada can now ban their teachers from wearing religious symbols? Of course, the judge did not address this question, but it's the question that I and a lot of people are asking. You know, if you're going to make exemptions for English language schools in Quebec, well, what about exemptions for French language schools outside? In both cases, the right to elected office and minority language rights, the judge is using an extremely exaggerated interpretation, indeed absurd. I mean, how can you possibly say that banning religious symbols constitutes discrimination on the basis of language? I mean, that's basically what he's saying. It doesn't make any sense. We're dealing here with a secularism law. It does nothing to do with language. Whether you speak English or French or whatever, it's irrelevant. The judgment rejects out of hand the fact that there are several European countries with similar legislation and often more extensive. He doesn't care. That point was made many times during the court proceedings, but he just rejects that. He also rejects Quebec's specificity within Canada while asserting Anglophone specificity within Quebec. This is inconsistent and hypocritical. That's how he managed to exempt English language schools in Quebec, but he paid no attention to the arguments that were made that, you know, Quebec being of French language and culture, they have a different tradition of secularism, which is more of the French variety as implemented in France. That specificity of Quebec, which is very relevant to the model of secularism you choose, he just dismissed that out of hand. The worst, I think, is when he rejected completely any comparison between political and religious symbols. He says banning religious symbols violates the soul or essence. He really said that, the soul or essence of the religious believer. In other words, he rejected this, the comparison with the Public Service Act. Religious symbols are much more important than political symbols. He also criticized Bill 21 for ignoring the law of gods. And I asked the question, does he think that the laws of God were written by someone other than human beings? I find his thinking to be medieval and theological. And as I mentioned earlier, he, in his judgment, just like the adversaries of Bill 21, he essentializes religious affiliation as if it were an essential, innate, and immutable characteristic of the person, like a racial identity. This implies the negation of freedom of conscience. And the adversaries of Bill 21 made a big deal of comparing to studies of Afro-Americans in the American schools. They had an expert from California, I think his name was Thomas D., who talked about how good it was that Afro-American students had Afro-American role model teachers who were Afro-Americans and showing them a role model of their racial identity and how good that was, and it helped their academic performance. And then they just simply apply this argument to religious symbols. So wearing the hijab is going to be good for Muslim students. If the teacher wears the hijab, that's going to be good for Muslim students, is the conclusion they draw based on a totally specious comparison between a religious affiliation and a racial identity.
Yes.
So, in other words, the judgment privileges religions by placing freedom of religion above freedom from religion, whereas they should have equal importance. It places freedom of religion above freedom of conscience, which in reality includes the other two as subsets. Freedom of and from a religion are subsets of freedom of conscience. And it places freedom of religion above freedom of political opinion, as we've just been discussing, using this soul or essence excuse. And in my opinion, a religious symbol is political, especially when it's worn by a civil servant in a position of authority. It becomes political if it wasn't already.
Oh, boy.
And the judgment denigrates secularism with expressions such as tyranny of the majority. The judgment summarized arguments of intervenors such as us and the MLQ and the PDFQ, but then just completely ignores them after summarizing them. And the judge's decision is based entirely on the arguments of opponents, with total emphasis on freedom of religion of civil servants and teachers, while completely ignoring the freedom of conscience of users and students, whereas there needs to be some kind of a balance. But no, totally focused on the rights of the employee. One positive point, he rejected the specious argument that Bill 21 violates sexual equality, which is guaranteed in Article 28 of the Canadian Charter, an argument that was made by some adversaries of Bill 21, saying that, you know, it discriminates against women. Fortunately, he rejected that, but he did not recognize the misogyny of some religious symbols. That point was also made by of course, by PDFQ, the intervenor, the feminist organization. But he didn't acknowledge that. But at least the judge rejected this ridiculous argument that Bill 21 discriminates against women. Next stop, Quebec Court of Appeal. And probably it'll go on to the Supreme Court of Canada, just like the injunction part did, you know, back in 2019 and 2020. So right now, we're preparing for the appeal before the Quebec Court of Appeal. The parties who are appealing to restore what Judge Blanchard struck down are, of course, the Quebec government. The MLQ and PDFQ have both indicated they're going to appeal. Unfortunately, we don't have the resources to be able to appeal. It's really expensive. And the parties who are appealing, who are in an attempt to get the court to strike down what Blanchard left in Bill 21 is, sorry, made a mistake there. I think all of them, or most of them, I keep getting news of yet another anti-Bill 21 who's decided to appeal. So most or all of those who are challenging the bill in the Quebec Superior Court will go on to appeal in the Quebec Court of Appeal. So it's going to be, well, I don't know how it's going to go. There's part of me that's optimistic because the Judge Blanchard's decision is so ridiculous when you read it, especially the part about distinguishing religious symbols from political symbols, where he talks about the soul or essence of the religious believer and the laws of God or the law of gods or whatever. It's just, I'm hoping that it'll get laughed out of court, but I don't know. It depends on what judge or judges happen to be sitting in the Quebec Court of Appeal. So the general situation is that the reaction against Quebec Bill 21 has been hysterical and fanatical and disgusting. I haven't talked about that much, but I'm talking in the media, by politicians outside Quebec. It's extremely hostile and very dishonest. And we've seen more of it just recently with this horrible killing that happened in London, Ontario. You've probably heard of it, have you?
Mm-hmm. Yes, we did. Yeah.
And they're making links to Quebec Bill 21, which is absolutely absurd. And this is really typical. There's nothing surprising about this at all. This has been going on ever since the bill was published. there's also these what some people call the woke, and which I, to be more explicit, call the anti-enlightenment pseudo-left. They made things even worse because they regularly conflate race with religion, because they're totally obsessed with personal identity. So they don't make any distinction between a religious identity and a racial identity, and so they're anti-secular, and they're extremely dogmatic, and impossible to discuss anything with. And the behavior of the opponents of Bill 21 during the Quebec Superior Court proceedings at the end of last year was disgusting, but no way surprising. It was just the same nonsense we've been hearing. And there is no atheist, humanist, or so-called secularist organization in Canada outside Quebec which supports Bill 21, and some even actively oppose it. There's an enormous degree of hypocrisy and cowardice and conformism, because
God,
everybody opposes Bill 21. They're too cowardly to speak up against it. And as a matter of fact, recently CFI Canada came up with a new definition of secularism, which is their definition from now on, and their definition excludes the principle of separation. In other words, their definition of secularism is based on religious neutrality, basically, that's the center of it, but not separation. And why? Well, obviously, so they can, so they don't have to support Bill 21, because, well, they're cowards, basically, because the campaign against it is just overwhelming, and it's easy to denigrate Quebec, you know, and as the woke do, they just classify Quebecers as white, therefore they're not a legitimate minority. So it's okay to be bigoted against them. So, and it's just totally nonsensical. Anyway, do I sound angry? Yes. So Quebec is in the vanguard of the Americas on the issue of secularism. Even though this bill is really modest and really moderate, it's very groundbreaking in this context. And there's the end of my talk. So,
Yeah.
Thank you.